Hello, everybody. For some reason, my camera is not working still. The office on the laptop. So we'll get started. Wait, it said they started at 2. So they were on screen for like a second, but they are starting at 2 o'clock promptly. So it looks like Darrell's nervous sitting there bouncing up and down in his chair. So he's got every right to be scared now. Little asshole. Um, so let's bring this up now. Any news about the Grand Rapids cop? Yes, Officer Scher is getting sent forward to trial. So yes, pie case, it's 2 Eastern. Yes, Officer Scher is going to go. He's going to have to face charges. He's going to have to face trial. Dan, how you doing? What's this about? This is about when they're going to hold the sentencing. And I'm sure there might be some other issues they're going to bring up. So I'm sure Darrell's going to spaz out like he's good for, and we'll see something funny happen. Hello, everybody. Hope everybody's having a nice Monday. Yes, there's going to be some subject matter jurisdiction, I bet. I'll turn this down here so it's nice and loud and ready. Yes, Jim. Hopefully you can hear me. He is going to get sent forward. They are going to trial on that case. The judge found probable cause. The judge chickened out. I'm very disappointed. But I also mentioned probable cause is not a high standard, so it's very easy to meet. So, remember I said don't be too surprised. Don't be too surprised. And that is where we are. What's all the background noise? I'm at the office today, guys. So there are the other attorneys. The other attorneys here have clients, so one of them probably is a little kid. Yes, Sarah Boone got moved to January 30th. Yes, due to lost luggage. There was a new attorney appointed, and he filed some motions. So,
Old Call State of Wisconsin
here we go.
versus Darrell
Here we
Brooks,
go.
case number 21 CF 1848. May I have the appearances, please?
State by Leslie Basie and Zach Witchow.
Sir, please state your name.
It got
for the
continued,
record.
Carrie.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and State for the record that I do not identify by the name stated.
The record to reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is appearing in jail attire today. The court is here to address a couple of things. Of course, the scheduling of sentencing. I also want to address a letter that was sent to the parties late last week on the 28th regarding the unsealing of search warrants, a filing from Mr. Brooks, and then an issue just as it relates to the record and the use of restraints during the trial, given a statement that was made by Mr. Brooks when the jury was coming out after they had reached their verdicts. So I'll start with the search warrant issue. The parties should have received the letter dated October 28th, advising the parties that the court will be unsealing all of the search warrants tomorrow, November 1st, unless there's an objection that is raised. Of course, that's based in law and fact. And I indicated in that letter we would address any objections at this hearing. So I'll start with the state. Do you have any objection to that?
No, Your Honor.
All right, Mr. Brooks?
I have not received anything. I'm quite sure, or I don't know if you knew, but the very second that I left your courtroom Wednesday, Your Honor, I was placed on suicide watch. I was told that it was per jail administration, that it was policy. It was nothing I could do about it. They immediately took me right from court, stripped my cell. I talked to mental health. They changed me right over into the SMOC. And I was basically placed on that. They just gave me regular clothes maybe 10 minutes before I came to your courtroom, Your Honor. So I haven't, I wasn't allowed any
We'll give
mail.
it to you.
Huh?
I had the letter printed off and we'll give it to you now so you can take a moment to review it. It really says everything that I just put on the record just now as well.
I accept for value in return for value this document.
He looks so scared right now. So scared.
I would just note there's a typo in your name, but so my apologies for that. Middle initial is indicated wrong. But it does reference this case number.
He is so scared right now. So absolutely scared.
When was this letter? Because like I said, I've been on watch,
Yeah.
so I haven't
100% on.
been able to obtain any mail whatsoever. Not from the courts, not personal mail, not anything.
So that was signed on Friday and then sent over. I'm not sure if it was emailed or if it was just delivered to the jail. I don't know if Madam Clerk has any information. It was done by my other clerk, but in any event, you have it before you. What I can tell you, sir, is that normally search warrants may be sealed for a period of time. All of these warrants were set to be unsealed previously, but due to the pretrial publicity and the various orders related to the jury, including the use of the jury questionnaire, I had, at the request of the parties and with the consent of all parties, sealed or continued the seal on all of these documents, and the previous order indicated that everything would be unsealed either November 30th or at the conclusion of the jury trial, whichever came first. Of course, the jury trial is now concluded, even though the case hasn't gone to sentencing. So my intent would be to unseal everything tomorrow, unless you have an objection and it's based in law.
I have, like you said, this is I didn't even know that this was even sent over to the jail until right now, until you told me.
Understood. Do you have an objection to what I propose to do so?
I don't even understand. What do you mean by sealed and unsealed? I don't.
It would become a matter of the public record, and anyone could review those search warrants if they make a request.
search warrants for what property?
There's a number of search warrants that have been sealed as it relates to this case.
From what I saw, everything's been pretty much public. I don't see why they need to be unsealed at this point. Everything's pretty much been public already.
All right, well, I am going to unseal them effective tomorrow. The clerk's office is instructed that first thing tomorrow morning, they may unseal all of the search warrants in this case. The next issue I want to address is I want to make a record specifically as it relates to the restraints that the Sheriff's Department utilized during this case, given a comment made by Mr. Brooks when the jury was coming out the very last time. I don't recall if you said something about a stun belt or shackles or something to that effect, but it was inaccurate. I have asked the Sheriff's Department to provide photographic documentation of the shackles that were utilized in this case. The parties will recall the tables look a little different now because there are no table skirts on them. On all defense tables in the secure courtroom, there is a ring. It's really more looks like a rectangle that is attached to the leg of the table, and an inmate who's in custody but in trial, a soft restraint system is utilized, primarily so it's soft and not heard. And then it's attached to the table so that it confines the inmate to a small area with that table. Obviously, during the trial, Mr. Brooks was able to stand. His hands were free, but I felt it important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public. And that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
Why would
the
that?
record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So
well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
there was no shock device.
It was a shock device. I was told it was a shock device.
Mr. Brooks.
And
that's
it was
why
covered up.
The record.
It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect the
of
ruling,
those
but it should be noted.
Your
it should be
objection is
noted.
noted for the record.
It should be noted that I had a shock device on my ankles. That's fact.
It
It's
is
a
not
fact.
a fact.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to require about what's being put on my body. I was told that they were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
Right,
public
Mr.
doesn't
Brooks,
deserve.
you're-
The public deserves
You've
to
made
know.
a record,
The
and
public
it's
deserves
noted.
to know about
And
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this
It's
voltage.
absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photographs.
Well, show
that
the
will be part
where's the
of the
photographs?
record,
Where's the photographs?
and they
You
will
just
be
said they would be
sealed
sealed. Why do they need to
from
be
public
sealed?
view
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the
I
public?
need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right, so
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today. But
I
I need to
don't
move on
want
to-
to be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown. That's
not
why I
right
had
at
a
all.
chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable.
I am surprised. This is very interesting.
And not tell the truth.
He
I'm not trying to dishonor you, Your Honor. I'm
He
not
got
trying
psyched
to
out.
disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else can be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your
Well,
characterization.
it's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need
There's
to move on to
there's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason
advising
why.
you.
And I always had the chair right here. Everybody that came in this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right
Yep.
here?
All right, Mr. Brooks,
Why
any
do I have a
further,
black cloth in front of the table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold
letting
me in
move
contempt,
on
that's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me
All right,
then. Remove me
Attorney
then.
Basie.
It's not gonna stop the fact that they need
All
to know
right,
that the shock device
he's
was on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll make the
That's fine.
appropriate
Tell the
findings.
truth, though, Your Honor. Tell the truth. I had a shock device
Captain,
on
can
my
I
ankles.
please see you? We're off.
Okay, so that's interesting. There were no shock collars put on him. They do exist, though. It is interesting, though. Either he was too stupid to understand that, or the deputies did lie to him and tricked him. Now, if they tricked him, imagine how helpful that was. Because he thought he was going to get zapped. Imagine how helpful that was. He thought he was going to get zapped. It probably kept him under control that entire time. Because if he knew that they weren't real, then he could have lost his mind and just started attacking everybody. So I think it's very, very interesting. Now, yes, some of you guys are bringing it up. They are not likely to release anything about their restraint systems because that is a security issue. That's a forced posturing issue. But while we have a second, I think it'd be funny to see the stun cuffs in action because they're a company made by Myers and you can see how they work. It's also just a guy getting tased, which is always fun. So, here we go.
I got it.
As you can see, he's got him strapped on his calves.
Let him drop. Let him drop.
What a baby. How long did it work? 5 seconds.
So, that is funny. But, let's get back to the trial in case they show up quickly. Uncle Bubba's bringing up a point. Did they lie to him? And if so, is that legal? I don't know. I don't think it would necessarily be illegal to lie to. Yeah, I don't know what this damn camera does not want to. Whatever. I can't get it to work. I started my laptop being retarded. Anyway, it's not illegal necessarily because it's not a violation of his rights to know, hey, if you do something out of line, this thing will blow up on you. So I don't think it will. And in fact, it kept him under control during the trial. So he would have to show some sort of prejudice to him by saying, hey, I thought this was going to attack me. So it should be interesting. Oh, hold on, I gotta get a text. So the tacit agreement, it was shocked. You guys are funny today. I hope everybody's feeling well. Yeah, it's deja vu all over again. The good old Darrell we know is back in the saddle. Rob Dorr. Also, yes, by the way, guys, Law of the Wild, Rob Dorr, Law of the Wild, is a channel apparently that Rob has now. I just checked it out. Looks pretty good. So give him a look. If you like what he's got there, give him a subscribe. I was tased and pepper sprayed in the academy. I'd rather be tased 10 times than sprayed once. I haven't been tased, but I have been maced before. Kind of earned it, deserved it when it happened. Getting pepper sprayed sucks. It very much sucks. Yes, Pie Case, that shot cuff is meant to be like a taser, but it's meant to be a concealed taser. Because that way it's already on the guy and ready to go. You don't actually have to connect to him. You have to worry about the clothes getting in the way. It's underneath his pants to give that neuromuscular interface. Somebody in the crowd said, what a beta, yeah. Yep. Yes, the cops can lie, but there's times where they can't lie. And this is a situation where I don't see how the lie affects his constitutional rights or his trial rights. Because certainly he would be under the impression that if he acts up in court, he would be disciplined by the police. So to say that we'll discipline you with a taser or we'll tackle you or we'll use these shock cuffs, either way is acceptable. I don't think those would be grounds for him to claim he had an unfair trial. So I don't think it matters too much. Yes, Manny Karavicius, you have a problem, call the cops. Now you've got two problems. Yes. Monica Lynn says he should have tempted fate. Yes. And Rob, you're right. I don't think it'll matter unless it comes with some threat or coercion. Even if there is a threat, he was already told, you can't do this. If you act up, you will get disciplined by the police. Okay. And they may have lied and tricked him about what it was going to be exactly, but that's not constitutional necessarily. He's going to have to show how it's harmful to him. Oh, crap. Oh, the court YouTube feed is paused. Oh. Good catch. Sure, brought that up.
Throughout this trial, I'm not going to do it today, but I will at a later point in time. Perhaps after scheduling, I will have a deputy testify regarding the restraints that were utilized so that there is a full and complete record about what was utilized and what was not utilized throughout this trial. It is absolutely false that a stun belt of any kind was used on Mr. Brooks. I don't know if he's receiving that information from other inmates, but that was not utilized in this case. It was a soft leg restraint setup, if you will, where he was shackled his ankles with the soft restraints and the soft strap so that it did not make noise. That was all attached to the table. And it is absolutely true that there was a black table skirt on the tables, both the state's table, the defense table in this courtroom, despite Mr. Brooks believing that it was not done for his benefit. It was to shield that information from the jury. It's also true that at all times when he has been brought into court, it's been before the court has been open to the public. If this court needed to remove him to the other courtroom, it was also done with the courtroom closed to the public. That was, of course, a security decision made by the sheriff's department. They are in charge of his security as well as the court security during any court proceeding in this courthouse. And it was their discretion and decision on what restraints would be utilized. And again, I'll go through that later and have a record made of what was utilized, including having one of the deputies identify what's on the exhibit. I'm not going to show that publicly. Again, there are security reasons. We don't, frankly, need inmates doing research or the public doing research on what these restraints are. There's an important security aspect related to keeping courts safe, keeping inmates safe, and that is why I'm sealing that information from public view so that their protocols and practices have that, frankly, veil of secrecy. It's important given the security issues. It's a law enforcement function, and that is my decision on that. As far as Mr. Brooks being in the other courtroom, again, I did that pursuant to the authority found in Illinois versus Allen. I did not hold him in contempt. Frankly, because it's a scheduling type hearing, I could simply have him taken back to the jail and he could appear by phone, but I've chosen to have him appear by video and audio means from the other courtroom. With that, I am going to address scheduling. I will be asking each party in turn how much time they believe they need to present their various sentencing remarks and whether anyone will be speaking on behalf. So I'll turn to the state first.
Thank you, Your Honor. To date, we have indications from the victims or their families that 36 people would like to either have a statement read or they'd like to read it themselves. We have approximately 5 to 10 others that would like to submit one in writing, which obviously wouldn't impact the time that we would need on the sentencing date. I would think that the state's comments would be between a half an hour to 45 minutes in total. So we're looking probably at about 4 to 4.5 hours. We will need some time to rotate victims out of the courtroom as they come in and to speak, because we can't fit everyone in the courtroom at one time. So we'll need to get one set in, get another one to room 115 so that they can hear what's being said. So we're thinking 4 hours, and speaking with the families and the victims Wednesday after the verdict. I think there's a strong desire to have the sentencing before the anniversary of the parade incident, and that obviously is November 21st. In checking with people, November 15th, 16th works for everyone. Specifically, the 16th works for everyone that would like to talk. I know that this court obviously has court calendars. I do have other dates that would work. Unfortunately, those go out to the end of December, end of November, beginning of December. But again, I can't emphasize enough. There are a lot of families who are leaving town the week of the parade, and I think the general consensus would be it would be nice for them to have some finality to this before they leave, so that they're not around here at the time that a loved one was injured or killed.
By any chance, did you have an opportunity to look at my calendar and some of the jury trials and talk with your colleagues? I mean, one of the cases, for example, I have on the 15th is an attempted homicide trial. I don't know if that's going to go or not, but just like this court gave,
It's going to be agonizing.
This case, I need to be mindful that that case has been scheduled since June.
I did not. I received these dates, although I believe that they were probably sent this weekend. I did not check my email over the weekend, so I did receive them this morning, and unfortunately, I did not take the time to do that. We can certainly look right now. Do you know who's handling that attempted homicide from our office?
I believe that's Attorney Sitzberger.
Okay.
There's other cases as well, because it's rare that I wouldn't stack trials. And so there's also another serious felony matter with Attorney Thurston for your office. That one was scheduled in August. I have another one with you,
Yes.
Attorney Basie. I'm just looking at the number of. Looks like I have 8 different defendants, many more cases, but 8 different defendants scheduled for jury trial on the 15th. The other thing is on the 16th, our CJCC has a very special meeting. I'm still the chair of that, and that is an anniversary of the CJCC that I do not want to miss. So not that I couldn't work around that, and it's not that I'm not willing to change, my calendar in any way that I can.
I can tell you, Attorney Witchow did reach out to Attorney Sitzberger. He indicated, and he said we could put this on the record, he's 98% confident that that will resolve, the attempted homicide will resolve. Attorney Thurston is not in the office today, so I can't speak to that trial.
All right, let me, before we look at dates, of course, let me talk with Mr. Brooks and find out how long he anticipates his sentencing remarks and whether anyone. So, sir, I have unmuted you. If you could speak to scheduling.
First, Your Honor, I would just like to say that I know you're well aware that I have ongoing matters in Milwaukee pending too. I have to be in court there in 2 weeks, and those cases are scheduled for trial as well. I haven't had the opportunity to speak with my representation over there because of the protocol that I've been on these past, I think it was 5 days since I last was in your court. I would like the opportunity to, now that obviously this was the big case, obviously. If it pleases the court, if it pleases you, Your Honor, I would at least like to get a disposition on what might happen there. I go to court there in 2 weeks. I'm sure that I would learn a lot more at that time. I'm not sure if I'm going to have the same representation at this point or if something's going to change with that.
Do you
So
know
that's
the
something that-
specific date that you're scheduled?
The 17th. That's for both cases. I don't know why they put both cases on the same date. And like I said, I don't know if anything's going to change between now and then. But both of those cases are scheduled to go to trial. And like I said, with the representation there, I don't know what's going to happen with that as of yet. There's been issues for months with that. I know that's something that Milwaukee has to deal with and not your court. But it would be a great help to me to at least be able to find out what I can find out about what can possibly happen there, and to also do any work that I may need to do on my end to prepare for that.
So I have looked at the dates. You are right. There's a hearing on the 17th at 2 p.m. The trial, though, in that case is not scheduled until December 12th. So my belief would be I could certainly see the judge in that case understanding if we had to go to sentencing or I chose to go to sentencing on those dates. And it looks like, again, both cases are scheduled for those same dates.
Yeah, it was kind of weird to me. The way they scheduled both cases on the same day was just kind of like, I didn't really understand why they did it like that.
Well, let's talk about a related issue, and that is, do you anticipate anyone speaking on your behalf at the time of sentencing?
I do.
All
I
right.
do.
And do you know how many people you anticipate speaking on your behalf?
I don't know an exact number, Your Honor. Rough estimate there be 20 or more. I have not yet spoken with everybody, obviously, because of the protocol that I've been on. I haven't had the chance to. Essentially, some people will be traveling to Wisconsin from different areas, different states. And I know they've expressed wanting to be there to speak for that. But like I said, me, myself, not being able to have the opportunity to speak with them personally, I don't know exactly how many. And I don't know how many people will be coming from different parts of the states. I would ask, if it pleases Your Honor, to be able to have everyone that does want to speak and does want to address the court, to give them the opportunity to be here for that. I know there's, as far as the people that are here in Wisconsin that will speak, one thing that they was stressed to me is that how is everything going to affect what's going on in Milwaukee? So that was like one thing that came up, and because I had totally forgot that the Milwaukee court dates were this close. And so I was just like, yeah, you're right, 17th, that's 2 weeks roughly. I don't know exactly where we're at in those proceedings. Like I said, there's still like some issues going on with the representation. I haven't been able to reach out. Obviously, I can't reach out from where I'm at, collect call wise. And I've had very, very limited interaction with the current representation in those matters. So I don't know what pleases you, Your Honor. I don't know what pleases the court, but I guess what I'm seeking is for enough time to know exactly who's going to be speaking, where they're going to be traveling from, and a little bit more information that I can provide to this court about the proceedings in Milwaukee County.
One of the things that I've done for other cases, and I know I was asked about this previously as well, and I would also offer it up to the parties, is I will also make available Zoom for victims, family members, including your family members, who would like to make a statement on your behalf. The only thing I ask, though, is I'm not just going to open up my Zoom to anybody. And so anyone who wants a relative, a victim, family member to speak, whether it be from the state or from you, Mr. Brooks, is I need to know who, no later than probably a couple of days before. I'm leaning toward scheduling this on the 15th, so that would be like the Friday before, which would be the 11th, so that when they come on the Zoom, they're identified, and then I let them in. So I understand your concern about the Milwaukee, but if I hold this on the 15th and the 16th, by your description of how many people, by what the state said, I think it's going to take about a day to hear the remarks from the parties. And then I would come fresh the next day to give the court's sentencing. And so probably a day and a half, but I'd set aside both of those days just to be on the safe side, in case it takes a little bit longer for either of the parties to present their sentencing remarks.
Your Honor, I'm not into.
Go ahead. Go ahead.
I was trying to make sure I didn't interrupt you.
Go ahead.
Your Honor, with all due respect, if it pleases your court, Your Honor, because of my situation, I could benefit from a little bit more time. I'm not asking for something outrageous here. Just enough that
This is
I can tie up
nonsense.
some of my loose ends, get you the information that you need to be able, if someone has to be present by Zoom or whatever the case may be, or to find out if these people are actually going to travel.
Absolute nonsense.
And also still be able to prepare for what I need to prepare for, because obviously I still, regardless to anything, I still have to be prepared to continue court proceedings. I still have to be prepared. It will really, really be a big help and a great benefit if I can have just a little bit more time to tie up the loose ends and get everything done in a timely fashion to be able to be ready to go and present.
What loose ends do you have making sure somebody gets your
I
Picassos?
understand that, sir. The issue that
You've got no loose ends, Darrell.
Obviously, if I wait much longer than that, I would, out of respect for the victims, avoid the week of November 21st. That's also Thanksgiving week. I don't think that would be an appropriate time for sentencing. But then after that, I do have, my calendar is just incredibly full. I have some time off in there. I have trials almost every week other than the week that I'm off, all the way up through the week of December 19th.
You have trials in December?
Again for the holidays.
Fuck that.
And so that puts us into January, and
Who has trials in December?
And plus I need to avoid the week of that trial in case one of your cases goes to trial. So I think I'm giving the parties ample time. I'm giving alternate ways for family members to speak, and that is by Zoom or in person, should they wish to be here in person. And I'm willing to clear my calendar, even of those trials. Hopefully my trials resolve, but to the extent that they don't, then I will clear Tuesday the 15th. Wednesday the 16th, though, I would not start until later that day, given the meeting I have to chair for the Criminal Justice Coordinating Council, or Collaborating Council. So that's from 8:30 to 10. I need to talk with our executive director a little bit more because I know we have a special type of meeting schedule, and I don't know if it will go longer. At a minimum, it would be safe to say the afternoon on that date. And no matter what, that would still clear Mr. Brooks to be in Milwaukee on the 17th. We're one county over. It's not unusual to do an order to produce that close.
I'm sorry.
No, so I am going to schedule it for the 15th and the 16th. The 15th will start at 8:30 a.m. And depending on, I'll be ready to go no matter what on the 15th. And if the state takes into the afternoon and then Mr. Brooks needs the rest of that afternoon or into the next day, I will certainly make those accommodations. I think I'm going to tentatively say we're going to schedule it for 1 p.m. on the 16th. And if anything changes, I'll let the parties know. And then I just need to know by Friday the 11th at noon who the parties are asking make their statements by Zoom with a listing of their names, so that when they appear on the Zoom, because then I'll approve it. We'll release the Zoom information. I need everyone to be aware, though, including victims, your family members, and it may not just simply give this Zoom information out. It will be only for those individuals that are identified by the state as wanting to appear by Zoom. I want to keep a tight control over that. And if I don't see a name either says a name that's been approved, let's say you had a friend by the name of John Smith. If John Smith doesn't say put on their Zoom info, John Smith, and it's just a phone number, I may not let them in. They have to be identified. Can't just give it out to anyone. And it's only for those individuals who want to make a statement, since the proceedings will be live streamed as well, whether that be how we've been doing it throughout the trial, or if I utilize the Zoom and the live stream I've done in the past, so that other people can watch it as well, and to facilitate the smaller courtroom that we have. So that's my decision on that. And at the I want to just very briefly have, I believe it's going to be Deputy Kibler who's going to testify about the restraints.
Looks like the 15th and 16th,
Yes.
guys. 15th and 16th.
I'm not trying to interrupt.
Go ahead.
You said, when is this supposed to be? Because I'm definitely gonna need a little bit more time than the 11th.
Mr. Brooks, I've made my decision. The sentencing will be on the 15th and the 16th of November. Anyone who wants to appear by Zoom on your behalf, you must file a request in writing no later than noon on the 11th. The same is true for the state. Everyone needs to be specifically identified so that I can make the appropriate approvals, and only those individuals who I specifically approve to appear by Zoom may be on the Zoom. The Zoom information can't be passed out further. And I'll create a special Zoom for that, and I'll make sure that I work with Teresa to do that and get that information when I approve that to the parties.
Your Honor, what if I'm placed on the protocol per the jail? What if?
Mr. Brooks, that's between you and the jail at this point. If there is something you need to first go through them. I'm not going to step on their toes with their protocols. I'm sure they'll understand this is a very important sentencing for you and make certain accommodations. They've done that throughout this case. I trust that they will do that as they determine is appropriate.
They haven't done it for the past week when I went on the protocol without even telling.
You're not going to get COVID. Yes, this will be televised.
And I was still placed on a suicide watch protocol.
I understand that, sir. I need to move on because I do have calendar this afternoon, but I want to have Detective Kibler come to me.
Your Honor.
Deputy, what did I say? Detective, did I give you a promotion? Sorry. All right.
But
he's going to come on up to the witness stand. I'm going to swear him in, and we'll go from there.
For the record, may I respectfully object to your ruling, Your Honor?
It's noted for the record. All right. Madam Clerk, swear him in, please.
For the record, may I respectfully request a legal reconsideration
All right,
of your
Mr.
ruling,
Brooks,
Your
I'm going
Honor?
to have to mute you because I need to keep going and I can't have this disruption. Go ahead. Raise your right hand.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Thank you, sir. Have a seat. I'll let you put your name on the record so I don't get that wrong. And so go ahead. Please state and spell your first and last names.
First name Nicholas, Nicholas. Last name Kibler, Kibler.
All right. Thank you. And you are employed in what capacity with the Sheriff's Department?
I'm a deputy for the Waukesha County Sheriff's Department.
I don't think so. You don't have a. All right, sir. Were you assigned to the trial of Darrell Brooks?
I was.
And can you tell us in what capacity?
My capacity was specifically, my responsibility was Darrell Brooks, along with Deputy Stanielson.
And were you in court at the start of the trial on October 3rd?
I was.
And did you come into court or work the court trial every day that we were in session?
I did.
And can you, were you at all in charge of the restraints? Let me ask you this. Do you have knowledge of the restraints that were utilized on Mr. Brooks throughout this trial? Can you describe those, please?
It's a soft restraint that we used. It was not any type of electronic control device. It was just a soft restraint that we applied to Mr. Brooks prior to coming into court every day.
And would that be a restraint system that was on his legs or something else?
It was around his ankles.
All right. Throughout the trial, the tables in this courtroom had black table skirts. Do you remember seeing those?
I do.
And did that hide from view in any way the use of the restraints from the jury?
It did.
And were the restraints also attached to the table in some fashion?
They were attached to the table by a tether.
At any point in time, were there any other restraints utilized in the courtroom?
There was not.
At any point in time, were there any type of electronic or stun device placed on Mr. Brooks?
There was not.
Anything you would want to add to the record regarding the restraints that were used in this case, sir?
Not at this time.
State, have any questions?
Just briefly, Your Honor.
Sir, you indicated that the restraints were connected to the table through a tether. Is that correct?
Correct. And then we would secure them with a padlock.
And how
On the
long was that
restraint.
tether?
The tether that was in here was 4 feet.
So Mr. Brooks could stand up.
Correct.
He could walk to his left briefly and walk to his right. Is that correct?
That's correct.
And that was the same rule that the state had, that we had to stand up and use our table to question witnesses. That was the same rule that applied to Mr. Brooks.
Correct.
Nothing further.
Mr. Brooks, you're muted. Do you have any questions regarding the restraint system as testified to by
Yes.
Deputy Kidder?
Yes, I do. And Your Honor, you can't practice law from the bench.
Your question, sir?
So none of your fellow deputies told me that it was a shock device when I asked what was being placed on my ankles at the start of this trial.
Not that I'm aware of.
Not that you're aware of. Do you know for sure that I was told that they were a shock device?
I don't believe that's the truth. I believe every time you had those devices put on, I was in there, and it was either myself or Deputy Stenielson putting them on, and I did not tell you that, nor did I ever hear Deputy Stenielson tell you that they were an electronic device.
So you were here every single day for every single moment of the trial,
Correct.
and you never heard any deputy tell me that they were. Matter of fact, let me back up. Do you recall me asking what was being placed on my ankles?
That I don't. If you did, we would have told you it was just an ankle restraint.
And you said that it was an ankle restraint. Did it have any metal parts?
Yes.
And what are those metal parts?
Metal part is where a strap went through and the locking device.
And what are those, particularly, let's say if a defendant in a trial attempts to, let's say, attack someone, what would be the purpose of those ankle restraints?
The restraints we had on you would limit your movement. So if you did try to do anything, we would have had enough time to control you.
And you state that, well, the prosecutors stated that the same rules were in effect for the defendant as the prosecution, but were they not allowed to put up exhibits to go to the front of the courtroom and put up exhibits?
They might have a few times, but
The record will reflect it was one time in the presence of the jury, and after that, I called them on it and said that would not happen. And then after that, it was only with the permission of the court and then outside the presence of the jury.
I don't believe that, Your Honor, you can practice law from the bench and answer the question that was asked to the.
Mr. Brooks, I'm in charge of the record, not you, and the record's going
I
to
didn't
be
say I was-
accurate.
I didn't say, well, it's not accurate. You're practicing law from the bench.
All right, Mr. Brooks, do you have any other questions for this?
Yes, I
witness?
do. Yes,
All right,
I do.
it has
Before
to
you
be
start-
about the restraint system. Please
Okay,
continue.
and was I allowed to approach the bench and put up exhibits at any time during this trial?
you were not.
And so how is it that the prosecution was able to do something that I was not able to do?
That's not for me to answer.
It's because of the shock device that was put on my ankles, correct?
There was no shock device on your ankle, sir.
I was told that it was. And you said that you don't recall hearing that being told to me, correct?
No, it was not told to you by me.
Yeah, by you, but you also said that's the point that I'm getting at. I'm asking the question. You said that it wasn't told to me by you. I never asked you, correct?
You never asked me, but I also did not ever hear Deputy Danielson tell you that they were a shock
I
device.
never asked you. I never asked you, yes or no?
No, you did not.
So do you know for sure if I ever asked any other deputy?
Well, considering I was in there when the restraints were being placed on you, I did not ever hear anybody while I was inside the bullpen while they were putting restraints on you.
So it'd be fair to say that you don't know for sure if I ever asked what the device was that was being placed on my ankle.
No, I can't be for sure.
So how do you know I didn't ask?
She needs to finish this. This is nonsense,
You don't have
Judge.
to answer that.
Finish this. Finish this.
All
Be
right, the
done.
record's been made. Mr. Brooks, I'm cutting off the
Thank you,
questioning.
Judge.
I'm just being
Done.
on for a moment. The record's been made. Deputy, you may step down. Mr. Brooks, if you have additional information that you want to provide to the court, I'd ask that you do so in writing and you provide the identity of any and all individuals you claim provided you with information that you were in a shock restraint. But I'll make a finding based upon the testimony of Deputy Kibler and also my knowledge of being in the courtroom every day and seeing Mr. Brooks being attached, meaning they would secure him to the table, they would unsecure him when he needed to move and other things. I'll make a finding that the soft restraint system was what was utilized and at no time was he ever in a shock type of device. All right, with that then, ladies and gentlemen, it is going to conclude the hearing today. We have the sentencing dates. I would also ask that any and all written material that either side wants this court to consider also be filed by the 11th by noon. So that's November 11th at noon. That will give this court ample time to review it ahead of the hearing on Tuesday, November 15th. All right, thank you, everyone. We are in recess. The court's going to take a short break before I start with my remaining affidavit.
I don't know exactly how much time he's facing on the next trial, but that's it. Casey NorCal. Yeah, once hate crime trial. Oh, yeah. Oh, so, yeah, guys, that was a bunch of BS, kind of what we thought was going to happen. He'd raise it, make a scene. I can't believe he's really going to have 20 people testify. That's insane. There's no need. I mean, there's nothing they can say that's going to help him. He's already facing mandatory life sentences without parole. So I don't get the idea. On an interesting note, I am not available the 15th. So yes, I have you guys, jeez. Yes, I am not available on the 15th. I have court that day. I have a trial. It's a misdemeanor trial, but it's a pretty important one. It's the one I got the hung jury on back in August, so I am going to have to do it. I don't think I'm going to be able to get out of it. And I'm pretty sure my client will not want to continue it. So I think I'm going to be doing that trial, and that's going to be something I have to deal with. So because I have to deal with it, guess who else has to deal with it now? You guys. So with it, you must deal. I did want to say, Corn Pop, thank you for that one super chat. I know there wasn't anything attached to it here, but yes, Pop Live, another one there. Thank you again for all those, Corn Pop. Tarkina Meyer says his mom wouldn't even testify during the trial. Yeah, I don't think she's going to testify, period. But she might. You never know. I mean, your moms, everybody's got their mom. And it was a hung jury. No, it was a hung jury, so. but it'll be fun. That was a tricky one to try, and I'm looking forward to it. Definitely looking forward to it. Yes, ugh, real life. I know. How dare people have their real problems? Yeah, I think his mom will be there. She's going to say, please don't. Please don't put my baby away. Oh, Lord, me. Me, oh, my. I could see it's all going to be like that. Brent says we need an axe and grounds emoji. We'll work on that. What else we got here? There's one I saw I didn't catch in time. Just in the map, nailed to the wall. What kind of fuckery is this? We need Mark Richards to come to come carpet bomb the stream with hard language. Yeah. Yes, we do. Though where is it? I can't find it. I could have sworn I saw it earlier. I could have sworn I saw it. And then I clicked on it, but I don't know if I started. That's the only problem I do not like about this StreamYard stuff. Yep, there we go. I found it. Yeah, just a map for $4.99. Thank you very much. I appreciate it. Yes, we need Mark Richards to come and carpet bomb the stream with hard language. Well, guys, I am in an office. I can't do that. The attorney I rent from, he's got people coming in and out. You know, I might potentially have people coming in and out that might show up unannounced, so I can't be doing that. MF Boat the First says, yes, he was trying to go to college to feed his daughter. His mom will say he's insane. Sure, she's going to say he's got problems and that shouldn't be held against him. But that doesn't matter. I mean, they have the right to punish him because he was found competent because he didn't go for his insanity hearing. He refused it. So that's his problem. Melanie says, congratulations to all the winners. Yes, congratulations to everybody. So, damn, why does this thing suck sometimes? This laptop is so damn slow with the internet. But yes, Rob, thank you for the memberships. I'm sure everybody who got one appreciates it truly. And yeah, that's it for Darrell. We will, like I said, I'm not sure who's going to do it on the 15th. I will speak ahead of time with them because I want to give you guys a place to go. It's not fair to send you somewhere and have it turn out to be a bust. So I will get that sorted out for you guys. And then if I'm available on the 16th, I might just hop on with whoever's doing part 2. But yes, it's going to be very long. I understand their idea of wanting to symbolically do this before the 21st, but I don't know if that an optic measure like that should be the court's primary concern. Although, I don't know if you heard me, this judge says she's got trials into December, which absolutely blows my mind because most courts hate doing stuff in December. And that's a neat secret for you guys. Once you get past Thanksgiving, most courts hate doing crap because now it's Christmas time already. And nobody likes to work at Christmas time. Nobody, especially the court system. That's a big secret. So I'm surprised she's going all out, but that's part of the issue of, taking off Alpha Fox. Have a good one. We'll see. I went for smokes and never came back. Yeah. But yes, most cases, most places only hate doing stuff after Thanksgiving, which is a really cool thing. Vince is saying I started with Viva Fry. Yeah, go. That definitely is not the right spelling. Only potentially criminal law and crime and court TV have it live. Oh, I think Nick's live right now. But yeah, on YouTube, wise, I'm not sure. You guys are taking off? Yeah, have a good one. I think just be hanging out for a couple minutes more, but yes, I do think it was very hilarious the way things worked out, and that apparently I thought they'd have the taser shackles on, but they did not, which is very interesting. And I can only imagine at this point if he asked and they just didn't answer him, and then he started panicking about that. And now he's probably felt very much like he got tricked. Oh, Legal Vice is live too? All right, well, I am done, guys. I got to get some more work done. I got to get some things ready. Got to get ready for Halloween tonight, pass out the candy. Guys, you come to my neighborhood, I can tell you this much. I'm passing out the full-size candy bars right now. And we'll be doing that tonight. It'll be a lot of fun. I will be doing a local stream after we're done with the trick-or-treating in our neighborhood, probably like 8:30, 9 o'clock. I'll just be I'll be hanging out, and we'll just be hanging out next to the fire pit talking. Yeah, Brooks is more unstable at the beginning, yes, but I have the feeling in the next 2 weeks he is going to slide really far. The cheese is going to slide all the way off his cracker, especially with his other cases and what he's got going on, and once he realizes what's going to happen to him. I think he's only gonna get worse. So let me see if I can send you guys to Jeff. If you guys want to go there and redirect over to him, because it's only 4 o'clock in the morning there for him, so keep him up. Okay, let's see here. How does this work? Customization. Redirect. Yep. All right, guys. It's all set for you guys to go over to Legal Vices when we're all done. You guys can really reality setting in. Oh, yeah. You know, if I had a chance, if normally 1 year I did do that. I handed out pocket constitutions to the kids. No joke, along with the candy. I did not do it this year. My girlfriend was against it, so I didn't do it. Yes, no Glocks for the trick-or-treaters. Yeah. So, yeah, guys, that is Merms says, can you give me a minute first? Sure, I'll give you a minute. Yep, it's over. Corn Pop, thanks for sticking around. I appreciate you popping in. All right, guys. Well, I gave you your minute, Merms. You've already had your minute, and I am going to switch over. You guys have fun with Legal Vices. Have a good day. Peace out. Oh, Merms for 10 pounds sterling. The King Sterling. Thanks, Sean, and enjoy. Appreciate it very much. Very much so. Thank you very much, Merms. I appreciate it. Always appreciate it, guys. Thank everybody thank everyone subscribed, everybody who commented, everybody who was just here, super chatters, everybody. I know that didn't get as climactic as we thought it was going to be, but it was all right. It was still entertaining. We need our Darrell fix. All right, guys. Bye.